Okay, a lot to discuss right here. Joining me here on Law and Crime, new guest, trial attorney Scott Major. Scott, great to have you here. You're joining us on a really incredible case. Now, I want to break down what he's saying. So after some, what you could argue, really incriminating testimony where he talks about the illumination in the apartment, talks about how the apartment smelled like weed. He also went into the idea of, what is proper protocol for an officer responding to a potential burglary suspect and how the defendant didn't do that. You could say this is really hurts the defense and that her actions were not reasonable. How is the defense doing under cross-examination, Scott?
I think the defense is struggling right now because I think that your points are well taken. The reality of this is that you have an officer who's a trained individual who could theoretically back out of that place, back out of that apartment, even if it was a mistake, or call for backup, or engage in the typical protocol that police do in this situation. And they haven't done that. And that's very troubling. And I think it forces the defense, in my opinion, to start to think about more of a humanization component of the police officer and more of an awareness of helping the jury to understand what a police officer might be faced with in this kind of situation, rather than the specific facts of this particular undertaking that caused the actual crime.
It's a fascinating case because you deal with a situation that if it's not centered upon was she reasonable going into that apartment or not, you have a case or you don't. Because even if we say, listen, she wasn't reasonable to go into that apartment, but okay, she's there. And even if then she's in this apartment she's not supposed to be and he tries to attack her, it's his apartment. It's reversed. He has the right to defend himself against somebody that comes into the apartment with a gun. And so it's a fascinating back and forth. I just don't know what the jury's going to do here because it sounds like a very complicated and tough case.
I think you're right, but I think that you've hit on something that's really critical and really important. It is his home. She is entering the home, and it's a bizarre set of facts where she doesn't know it's not her apartment, even though there is a giant red floor mat right in front of the apartment, and there's other indications that it's not her apartment. And then she fires in what seems to be a troubling situation. My comment earlier was more to, I think that the defense should spend more time with painting a picture of the humanization of what police officers face, what this woman faced, in order to establish more of a believability or a likability of the reasonableness of the situation. I think antiseptically, it's a bad situation for the defense. And I think when you start to hear these people talk antiseptically, what happened, give me the facts, I think that hurts the defense immensely.
Well, maybe that's what they'll do when they're ultimately handed the case. We believe this is going to be an interesting back and forth from both sides, but you nailed it so well. So many opportunities for her to realize that was not her place, including what we saw today. The apartment was illuminated. She should have seen it wasn't her place. So, Scott, this is interesting because they're trying to decipher and say to this jury, well, if she really thought it was a burglary, maybe she was justified in using deadly force. But one of the things we mentioned earlier on is when you look out at the layout of the apartment, he was seated in this couch. There was an ironing board right in front of him. So it might have been difficult for him to get up and run towards her and be that kind of threat that the defense is trying to portray. It wasn't as if she opened the door and he was right there. I'm curious what you make of what we just heard while this officer was on the stand.
I think you're absolutely right, and I think she's got a difficult case. I mean, I have a brother who's a cop. I have a father who's a judge, and I'm telling you, she's looking down the eye of a conviction. The only way that I see that she can present that is to start to create some humanization with the jury, to get the jury to understand what an officer faces, how dangerous situations are, because people don't understand them. They don't deal on a daily basis with that. And you have to start to get the jury understanding what her mindset was in order to possibly believe that there might be a chance for a reasonable feeling that the jury would have if they were standing in her shoes. Because it's not a pretty sight. You're entering somebody else's apartment. You're trying to extract your way out of this nightmare situation when it's not your place. You know it's not your place, or you should know it's not your place, and you're discharging your weapon when there isn't a lot of evidence showing that this gentleman attacked her. So I really think that if I was the defense, I'd be focusing on trying to paint a picture exactly of what an officer faces, what situations are, how quickly you have to respond in situations to help the jury to understand why it might be reasonable in this situation to do that. And especially having an officer of color do that, I think would be a very effective tool.
Yeah, and listen, they were saying you might be able to plan for a situation where you get a report, a dispatch, you're entering into a case where there is a burglary going on. You may take cover in that situation. You can plan for it. But if you're walking into your apartment off duty and you see somebody, you may react differently. However, as we keep saying, it was her mistake. There were so many opportunities for her to realize this wasn't her apartment. You said it earlier. I said it at the beginning of the day. I think the whole case rests on that red floor mat. And even if you want to say, because her apartment didn't have that red floor mat, yeah, you might be able to say, maybe she didn't look at the apartment door. I know I've done that before. I haven't looked at the other apartments down the floor or maybe in a hotel. And if the number isn't even on the door, okay. But then you smell weed. And now they're trying to say, well, the whole the whole building might have smelled of weed. But these are two indications. And again, if it's as illuminated as we saw in that body cam footage, if she were to walk in, she should have realized immediately this wasn't her apartment. And aren't officers trained at that point to react in a more conservative way than an average Joe who has a gun? That's the question I have.
I think your analysis is right on point. And I think that, again, I think she's looking at a conviction unless she can start to get people to understand how it might be reasonable in her shoes to do that. And the only way to do that, in my mind, besides her taking the stand, which she has to do, is to make sure that all other officers can explain what it's like in the life of an officer, then combine that with entering what you perceive as your home, and that it might be reasonable to create some doubt. Because remember, we're trying to create reasonable doubt in the minds of the jury for an intentional act that is murder.
Now, how much are you swayed by the idea of, was she tired or was she not tired? So in a perfect world, the defense could say, this woman just worked I think it was a 13-hour day. She was exhausted. She couldn't see straight. She was almost sleepwalking back to what she thinks is her apartment. She walks in, she sees somebody, and that's it. That'd be a great case. However, the problem is, what the prosecution keeps presenting is that she might have been trying to see her partner that night, a guy that she had sexual relations with in the past, and maybe that night she's flirting with him. She wanted to do a little bit more. She wanted to do extracurricular activities. But the question of how tired was she, what was she planning to do when she got home, are you persuaded by that by any which way, or is it of the case, look, we can all agree she wasn't too tired to not realize what was going on?
I think she was not too tired to realize what was going on. I think that the fatigue component really doesn't sell well in the end. So you're trying to say that because I was tired, it's okay that I killed somebody? I don't think that works. I think what you do is you try to, again, humanize her, humanize the fear that police officers have in general, recognize to put their lives on the line every single day, and explain to the jury what that's like. Then how somebody approaches, if it was entering your home and you thought mistakenly it was your home, what would you do if somebody that you perceived was coming after you? What kind of force would you use? I think that component works well. And then you put her on the stand and you let the jury believe how unbelievably sorry she is, and that she was actually acting reasonably, that she truly believed, even though mistakenly, that that's the case. Because you're not going to prove her innocence. You just have to create the reasonable doubt. And the only way to do that is to create this humanization and use this kind of witness, this exact witness who's on the stand, to explain to a jury what it feels like to be a cop, right, what it feels like to be in this situation. I mean, it's just so important.
And like you said, we believe she's going to testify, and maybe that's her opportunity to do so. We're going to take a break. When we come back, clearly a lot to talk about. Stay tuned here on Law and Crime. We'll be right back.